Good afternoon. My name is Alina Shevtsova. I am an immigration attorney from Brooklyn, New York. In today's legal speaking seminar, I would like to talk to you about renewal of your adjustment of status application in immigration court. Many people think that when they're referred to immigration court, it's usually they consider it to be a negative factor. And often it is, because now a person is in removal with deportation proceedings. But at times, a person is better off when he or she is actually referred to immigration court, because sometimes there are reliefs and various applications that are available only in immigration court. And immigration court sometimes look at and have to consider various factors differently under different regulations than USCIS. Because ordinarily what happens if when a person is trying to file for adjustment of status, they would file the application with USCIS. That's the regular course of events. But USCIS has very rigid rules about adjustment of status, and at times the person, for technical reasons, cannot meet those standards. And immigration court at times provides a person with a greater flexibility. For example, renewal of adjustment of status application in immigration court can sometimes have its own benefits in immigration court opposed to USCIS. Cancellation of removal application is available only to those who are referred to immigration court. And not to have a 3-year bar if you overstayed your visa, if you accumulated unlawful presence of more than 180 days but less than a year. At times the relief is available only in immigration court, so that you will not have the permanent bar if you leave the country within that time. So immigration court at times has its own advantages. This video specifically is about adjustment of status. So what happens with adjustment of status? Adjustment of status is a green card application that has to be based on some sort of a petition. Traditionally, it would be I-130 petition for a relative by a family member, I-140 petition by an employer to sponsor a foreign worker, I-360 petition for a special immigrant. So this particular video is about a very interesting point in immigration law. It's about renewal of adjustment of status based on employment petition in immigration court. The most common denial of adjustment of status when a person is filing based for green card based on employment is that the person failed to maintain lawful status in the United States, so that his employment application, his employment-based green card application can be approved. It's called 245C2 section, if I'm not mistaken. And it's very common. What happens is that the person falls out of status. Let's say a person filed, for the person I-140 was filed and it was approved, and then the person filed for adjustment of status I-45, but it was denied, and then the person refiled I-45 based on that approved I-140, but by then the person failed to maintain lawful status, and the person's second I-45 will for sure be denied by USCIS, because now there is a hole in the person's status. So guess what? If that person is referred to immigration court, the person can refile or renew, let's say it's a more correct way to put it, renew the I-45 adjustment of status application based on the same I-140 petition, right? But now the person does not have to meet requirements related to the lawful status, 245C2. They don't have to meet the requirements for that section, and that bar is no longer applicable to the person. So that's very important to know. That's like a loophole or secret of renewal of adjustment of status application related to employment in immigration court. Very, very important. So not always referral to immigration court will be a disaster. Sometimes it actually works to your benefit. And you can read more about this particular situation on our website, www.shoutsova.com. It has references to the case law that may help you if you're facing a similar situation. Thank you.